They may take you from me, I'll miss your fond caress. But though they take you from me, I'll still possess the way you wear your hat, the way you sip your tea, the memory of all that. Oh no, they can't take that away from me.
All right, folks, welcome back one more time. You've already seen two videos about the Kelo versus New London decision. One, the argument for the city of New London, in other words, the argument that won at the Supreme Court. And the second one, the argument for Mrs. Kelo, the argument that lost at the Supreme Court. In this short video, I'm going to go through really just three things that you need to know about regulatory takings. Three cases that established landmark precedents on this issue of regulatory takings. The first of these cases is Pennsylvania Coal Company versus Mann in 1922. So this was a case in which the Supreme Court of the United States decided that whether or not a regulatory act constitutes a taking requiring just compensation depends on the extent of diminution in the value of the property. So this was the decision that started the doctrine of regulatory taking with what you can think of and what we're going to label the diminution of value theory. So the takings clause of the Fifth Amendment originally applied only when the government physically seized or occupied property. Prior to Pennsylvania Coal Company versus Mann, American courts followed a clear rule. Regulation of land was never a taking. Rather, it was simply an exercise of the government's police power, as it's called, to protect the public health, safety, welfare, and morals, and so on. Those are actually the traditional categories lumped under the police power. So for this case, let's look at the facts. In 1878, the Pennsylvania Coal Company granted to Mr. Mann the surface rights of a parcel of land, but retained the mining rights underneath that land. As part of the agreement, Mr. Mann accepted any risk that might have come from this, and he waived any claim for damages resulting from any mining that might actually occur below his property. So for instance, imagine that his land sunk or subsided because water had been drained out from underneath it. With things like that, he accepted the risk. But then in 1921, the Commonwealth of Pennsylvania passed a law which prohibited the mining of coal in such a way as to cause the subsidence of land at all, especially any structures that were used as human habitations. So in other words, they changed the conditions of the contract between Mr. Mann and the Pennsylvania Coal Company. And that's what gives us our legal issue. Now this is going to get confusing for a second, but follow along here. Prior Pennsylvania law had already recognized that pillars of coal that were necessary to support the land service were an estate in the land. It was called a support estate, and that was separate from the rights in the removable coal. So remember when I said just a second ago that if they had mined the land in such a way that they drained out water, and then Mr. Mann's land sunk, then the Pennsylvania Coal Company would not have been liable for that. Mr. Mann had already agreed to waive any right to sue on that basis. But like I'm telling you here, there had already been a Pennsylvania law which said that if they dug out the coal and these pillars of coal, because they were missing, now the land subsided, Mr. Mann was already protected from that. Or in a more legal sounding way to say this, Mr. Mann already had the support right or the support estate in his land. It was already the case that the coal company did not possess the right to make his land sink totally by taking the coal out from underneath it. That is not a power that they had. That is not something they would have been allowed to do. But nevertheless, something had actually been taken away from them by this new Pennsylvania law. So in 1922, Pennsylvania Coal provided notice to Mann that it planned to mine for coal under Mann's house, and he brought suit to prevent that under this new law. And the Supreme Court argued as follows. One, the damage that might be done by this mining is a private and not a public nuisance. So there could be no public safety justification for this new 1921 law. On the other hand, the damage done by the new law is fairly significant to the coal company. insofar as it abolished the subsurface mining rights that the coal company had actually had. It gave man a power to block that subsurface mining. And two, the court said, the statute made it prohibitively expensive to mine coal across almost the entire state, and therefore effectively destroyed anybody's right to mine coal. After all, owning coal isn't worth anything if the coal can't be extracted, if it can't be mined. So regardless of man's prior consent to abide by the company's mining rights, the statute, this new statute, was invalid. There need be no such prior agreement between the company and the person. Any and every company had had its rights diminished by the law and therefore had suffered a taking. Sure, there were things that the Pennsylvania Coal Company could and couldn't do to man under their previous agreement. They could, for instance, extract water and make his land subside, but they couldn't, under that older Pennsylvania law, subtract the columns of coal and thereby make his land subside. So there are things that they had to do, rights that they had and rights that he had. But the Supreme Court, in this case, said that what the new law, the 1921 law, had done was it had basically removed anybody's rights to mine coal in the state of Pennsylvania, and thereby every company that had a subsurface right to mine coal had effectively had that right taken. And so the court decided that Pennsylvania had no power to grant to folks like Mr. Mann support rights without actually giving compensation to others for those rights, what it removed from them. So the near complete diminution of value in the subsurface mining rights of the Pennsylvania Coal Company was, in fact, a taking covered by the Fifth Amendment. Okay, now let's look at a second Supreme Court case that elaborated on the principles stated initially in Mann. This case is called Loretto versus Teleprompter Manhattan CATV Corporation from 1982. And this is a case in which the Supreme Court held that when the character of a governmental action is a permanent physical occupation of property, the government action brings about a regulatory taking, regardless of whether the action achieves an important public benefit or has only minimal economic impact on the owner. So in deciding this case, they established what's come to be called the permanent physical presence test for regulatory takings. Even if the property isn't taken totally, as it had been in Pennsylvania Coal Company versus Mann, remember that in that case, the court said it was a near complete taking, granting all these rights to Mr. Mann to block the rights that the coal company had, took those rights entirely, and so should be viewed as a regulatory taking. But here the court was saying something slightly new. Even if the property isn't taken totally, if some part of it has a permanent physical presence on it that's required by the government, well, that's a taking. So for Loretto versus Teleprompter Manhattan, let's look at facts and law together. New York City law required certain property owners to permit installation and maintenance of certain cable television wires on their property. Jean Loretto owned a 5-story apartment building. Prior to Loretto's acquisition of the property, Manhattan Teleprompter installed cable television wires on it. Loretto sued Manhattan Teleprompter for trespass because of the remaining cable boxes and wires on the exterior of her building, and insofar as the teleprompter company relied on the law, she said this was a taking by the New York City government. She requested damages for the trespass, and she requested just compensation for the taking. The New York Supreme Court, however, upheld the constitutionality of the law. They said that the permanent installation might constitute a taking, but here the law served a legitimate public purpose, and there was no significant economic impact on Loretto, the issue that had been considered in Mann, and so they ruled against her. Notice again, they said it might constitute a taking, but because of the public purpose served and because of the minimal economic impact on Loretto, they were allowing that taking to occur without compensation. The US Supreme Court reversed this, articulating a new rule in the process. The Supreme Court argued that regardless of whether the action achieves an important public benefit or has only minimal economic impact on the owner, Manhattan Teleprompter's, quote, permanent physical occupation of Loretto's property constituted a regulatory taking of property for which just compensation was due to her under the 5th and, you'll note, the 14th Amendments of the Constitution. And that brings us to our third important regulatory takings case, Lucas versus South Carolina Coastal Council from 1992. So this was a case in which the Supreme Court established the total takings test for evaluating whether a particular regulatory action constitutes a regulatory taking that requires, of course, compensation. So here are the facts of this case. Mr. Lucas purchased 2 beachfront properties in 1986 for $975,000. They were both vacant. The state's Beachfront Management Act then passed in 1988, effectively preventing him from erecting homes on his properties due to the effects that that would have on the public beaches nearby. In fact, there were public beaches, wetlands, and waterways nearby. So then let's consider the important legal issue. Mr. Lucas filed suit asserting that the restriction on the use of his lots was a taking of his property without just compensation. The lower court agreed, and it awarded Mr. Lucas $1,232,387.50 as just compensation for the regulatory takings. The state of South Carolina continued to press its claims, but the Supreme Court affirmed the lower court, denied South Carolina's claims, and in the process stated a new rule. They said that a regulation that deprives an owner of all economically beneficial uses of land constitutes a taking unless the prescribed use interests were never a part of the title to begin with. That might sound complicated, but it's really not. In other words, if Lucas had already had the right to build houses before the statute, then the total taking of that right was a taking. However, the court said Lucas's right to build could be limited if it created a public nuisance. So as a result, the total takings analysis or rule or doctrine requires a balancing test of sorts with 3 parts to it. First, the degree of harm to public lands or adjacent property that would actually be posed by the building. Second, the social value of such activities. And third, the relative ease with which the alleged harms could be avoided by less restrictive means, for instance, by requiring Mr. Lucas to build his homes in another way. So the Supreme Court majority in this case argued that deprivation of all economically beneficial use is, from the perspective of a property owner, deprivation of the property itself. They said that regulations that restrict all economically beneficial use may often just operate as a disguise for putting that private land into public use for a public purpose anyway. And if so, the land has now really been taken for public use, as we might think that the land was taken to sort of make the public beach in a certain sense. If Mr. Lucas was told that he couldn't do something so as to protect the public beach, or to protect the public waterway, or to protect the wetlands, then in some sense, he was being told that he couldn't do that thing in order to make the public beach, waterway, wetland, what it would be. So the Supreme Court was saying that there's really no clear way to distinguish regulation that prevents a harmful use from regulation that confers benefits on nearby property instead, or confers benefits on the public. They have to be seen in conjunction with each other. So the state's claims could simply be seen as an attempt to benefit the beach, benefit the waterway, benefit the wetlands, and thereby benefit the public. There was, in essence, a public purpose to the regulation itself, meaning that the regulation should be considered a taking. Okay, so there you have it. 3 cases that express 3 rules that I want you to use in class when we encounter our test case. The first rule being the diminution of value rule, the second being the permanent physical presence rule, and the third being the total takings rule. Okay, I look forward to hearing what you have to say when you're presented with our test case in class. See you then.